In case the accused person has to be held in custody, then the compelling reasons must be given. In that particular act, it does not say what those compelling reasons should be. So they are not definite. The accused person was brought to court and was charged yesterday. But prior to that date, we had filed reasons by the family, that is the siblings of the late Cohen, as to why she should not be released on bail. But as well as we are doing that, we must also look at Article 28 and Article 29. Article 28, where a person shall be treated with dignity. And Article 29, where a person shall always be enjoying protection of the law. Tob Cohen is dead, is buried. Those particular rights of his, he did not enjoy. And while the accused person might want to say that she is innocent, from the family side we know that she's the one who is in custody now. So our fingers must point in that direction. And we are saying that out of her act, it is the reason why.
Just a moment.
Yes.
Continue, please.
Yes, yes. Out of that very bad act, the late Tob Cohen has been denied those rights. But defense counsel comes into court today and does not dwell on issues as to why the client should be released on bail, and starts by attacking persons who are not in court today. Attacks Mr. Guerrori, attacks Catherine Mwaniki, attacks everybody, murders everybody. The only person he praised well was me. But Your Honor, the moment counsel made an application for bail, he took up the burden of trying to show also this court why the client should be released on bail. And he has given his reasons. One of the things he says that she should be released on bail is because there is no evidence. There is no post-mortem. And there's no other reason. But the state has filed an affidavit. It shows the post-mortem report, and it has also attached statements of persons who they consider to be vulnerable, and so do we. So the accused person is not in court today because of nothing, but is there because of an offense, and it has been committed. And as state has said, the investigation is ongoing. So at this particular moment, the accused person should be at least at the moment cooling and waiting to see what evidence is there. Until you are told there is no more evidence, there is no more investigation, then that is the time for him to say that there is no evidence. At this moment, he's just crying wolf. So this burden then he needed to show to this court was one. We expected that the accused person would be able to say in the application where she is going to stay. Because at this particular moment, the only abode we know right now that she is in Langata. So out here, where is she going to stay? She needed to tell the court this. She needed to convince the court she has a place that she can be found. Because today, if we need her, we only need to issue a PO, and she's brought. So we have the benefit of having her within reach. This matrimonial home that is being spoken about, it is a crime scene. It cannot be interfered with. It is sealed. She cannot then be going back there. So what I'm trying to say is that in as much as she has not volunteered information about what she's going to say, we are also saying that she has no place where she can go to. So she's better off where we can get her. You're being told she's not a flight risk. Up to until this moment, we're being told we needed to place material before court. But one of the reasons why she has not taken off is because she is in custody. She is with the police. The police are holding on to her. She cannot take off them. So again, that gives us the benefit of having her here when and where we want her. You're being told that the passport has been taken by the police. She volunteered it. How does that prevent her from taking off? You might be told here by counsel and the accused person that she will not take off. But what guarantee then do we have? What guarantee do we have? We don't have any. So what would be the best solution to this, Your Honor? Keep her in custody so that she will not be going anywhere. Your Honor, you've been told that she will not interfere with witnesses. Let me see how to put this. When this application is made in court and filed in court, it is by instructions of the accused person to the counsel. But then when I look at the application the replying affidavit that has been put on, that has been given by the state, counsels on record, both my senior Mr. Murgor and Mr. George, are mentioned as people interfering with the case. They are mentioned in that OB as persons who have coached witnesses, spoken to witnesses and told them what to do. It is in the OB. So when they were doing these things, were they instructions that were given by the accused persons, or were they instructions that they took upon themselves to do so? Because they have not denied this. So therefore, does it make that accused person a safe person? Or the counsels? Because then both of them are now dangerous. So if in custody the accused person can pass information to another co-accused person, another person would be a co-accused, and giving instructions on which phone number to use, how do we trust these people? Because even that one has not been denied. How do we trust those people? So, Your Honor, this then becomes the material that you need, because now these allegations are there. The phone number has been given, and counsels have been mentioned. In any case, Your Honor, the accused person, the deceased, as you will see from the affidavit that has been attached, you will find that the postmortem that has been attached there shows the gruesome manner, the very grotesque manner, the kind of death that the accused person met. The number of injuries on that body, if you count them, they're amounting up to about 30. The person who committed this offense must be then a dangerous person or a bad person. That person then cannot be allowed in society, at least not now. And when we have the accused person as the only person we can point to at this particular moment, then we are stuck with her. The state has indicated that they have witnesses who are vulnerable. And up until that time that we are going to have those persons in protective custody, then they remain outside there as vulnerable persons. And if they are, and the accused person who has been an employer to them, can be able to interfere with them. That way, we will not have witnesses in this court. Or if we have them in court, then they'll not be honest because they can be tampered with, if I can use that word. So until the day we are told in this court that yes, they have now gotten a place where they can stay and they are safe, please keep the accused person in custody. Even if we hear these witnesses, let them testify, then that time they can be released, she can be released. But even at that time, we shall still be objecting. Gabriel Cohen and Bernard Cohen have sworn affidavits in this case. And we are being told they stay in, what did you say they stay? In Holland, in the Netherlands.
Your clients?
Yes, yes. You volunteered the information, so I wanted to know.
Even we don't know anything.
Yes, and Your Honor, when they made this affidavit, where were they? The affidavits were made here. They have been living here. They are witnesses in this case. And when they come in this country, they'll be witnesses, and we don't know how many times they will come or where they'll be staying. So they're telling you they're afraid. They're telling you that they fear. We cannot wish that away because they are staying far. But when they are here, are they really then secure? And they are saying they are afraid of the accused person. If we need them as witnesses, then we need to have them secure. Then we also need them to have the accused person again remaining in custody. All these stories that have come out about the will and the properties and all that, those ones can be handled at the time when that moment reaches. We'll be taught by that event in its hour. I know for a fact that anything that is said about the will has only been read in the papers. Counsel is available. Counsel has been able to make affidavits for her. Counsel has been able to come and present her in court today. Why? Because she has been able to give instructions. So when it comes to matrimonial property and the affidavits and the wills that are going to be made, counsel is able again to take instructions and follow it up. We are talking about a trial. And at least we were sympathetic enough to say, as long as she's still in custody anyway, the matter can be heard fast. There is nothing wrong with that. We are not saying that the matter be heard as fast as possible. We are saying it can be heard without undue delay. So, the suggestion that she stays in custody as we hear the matter as soon as possible is nothing wrong with that, because that is also an option. The state said the body was found immediately when the accused person was charged and had been kept in custody. The persons who were in that compound, who are our employees, were able then to speak up. And a body was found in the compound. And she's the only one we have here today as an accused person. But for her to be able to live in that house and a body has been in that house.
I think we are going beyond his affidavit, and if he wants to give an affidavit, he should.
Your Honor, I'm talking about what has the state has given as an affidavit. It
Yes.
is something that is in the affidavit of the state, and the state has said it, and he did not object. So I'm only emphasizing on it. I'm not bringing anything new. It's what has been said. Only I'm putting it in a better way.
The position of the accused is the body was not there; it was brought there. So don't say that it was.
That is the position of the accused
Okay,
person,
okay,
but our question is
counsel.
different.
Let's just proceed.
Yes. If this body then has been found there, and I'm using the word if, she had been living in that house all that period of time, what kind of a person are we talking about? We are talking about a dangerous person. So therefore, protect the witnesses, protect everybody else who is in this process. And if it's Muiruri, he can protect himself. That is all I wish to state.
Yes.
In reply, how long